Judicial error as power, when mistakes become untouchable. Most people believe something very simple about courts. They believe that judges are required to follow the law, not interpret it creatively, not bend it, not replace it with discretion, but follow it. And if a judge violates the law, most people assume there must be a remedy. Today, I want to talk about why that belief is only partially true, and how, in practice, judges possess something very close to an unconditional right to legal error, even when that error violates statutes, procedural rules, and sometimes constitutional protections. Judicial error is not accidental. It is institutionally protected. Let's address something that is usually presented as harmless, but isn't. We are often told that judges are allowed to be wrong because they are human and because appeals exist. That framing is misleading. Judicial non-accountability for legal error was not imposed from outside. It was constructed from within the judiciary itself. Through doctrine, precedent, and interpretation, courts have declared that violating statutes can be harmless error. Ignoring mandatory rules can be discretion. Misapplying constitutional protections is not reviewable. And that judicial error, no matter how serious, carries no consequence unless reversed. This is not comparable to ordinary human error. In almost every other area of society, errors carry responsibility. Violations carry consequences. Authority increases accountability. In the judiciary, authority reduces it. The justification is always the same: judicial independence. But independence from pressure is not the same as immunity from law. When judges write the rules that excuse their own violations, and then interpret those rules to shield themselves from review, error stops being a mistake and becomes protected conduct. That is not an accident of the system. That is the system. When error becomes unreviewable power. In theory, legal error is corrected on appeal. In reality, appeals are expensive. Appeals are slow. Appeals are discretionary. Many rulings are effectively unappealable, especially discovery rulings, procedural denials, motions to compel, enforcement of mandatory rules. These decisions shape the case, but rarely get reviewed. So the judge's error becomes final, not because it was correct, but because it was unreachable. That is not judicial fallibility. That is structural immunity. Mandatory law versus discretionary outcomes. Here is the core contradiction. Our system contains mandatory statutes, mandatory procedural rules, mandatory disclosure requirements. These laws use words like shall, must, required. But when a judge declines to enforce them, courts respond with, "This was within the judge's discretion." Think about what that means. A mandatory rule becomes optional. A legal requirement becomes a suggestion. A violation becomes a judgment call. And once something is called discretion, it exits meaningful review. Vague standards create unlimited space. This is not accidental. The system relies heavily on vague standards. Reasonableness, fairness, interest of justice, proportionality, case management. These words sound responsible, but they have no fixed content. They allow a judge to enforce the law, ignore the law, delay enforcement, deny enforcement, all while claiming compliance. The vaguer the standard, the less accountable the decision. Why constitutional violations rarely get labeled that way? Most people think constitutional violations look dramatic. They imagine censorship, arrests, explicit punishment. But in civil courts, constitutional violations are usually procedural. They look like refusing to enforce mandatory protections, allowing one party to withhold required disclosures, imposing cost risks that deter legal action, allowing retaliation through process. Courts respond. You were heard. The judge ruled. Due process was satisfied. But due process has been reduced to participation, not law enforcement. The illusion of due process. Due process today often means only this. You were allowed to file papers. The judge issued an order.
It does not mean the law was applied correctly, mandatory rules were enforced, rights were protected. Courts explicitly say judicial error is not a due process violation, even when the error disables the right itself. That is how constitutional protections survive on paper but fail in practice. Why this is practically unlimited power. Here is the uncomfortable truth. A judge can ignore mandatory law, deny enforcement, allow procedural retaliation, increase one party's risk, chill access to justice. And as long as no explicit punishment is stated, no improper motive is proven, no extreme language is used, the action is insulated. This creates a system where power is exercised through discretion, accountability is deferred indefinitely, error becomes functionally untouchable. This is not about bad judges. This is important. This is not an argument that judges are corrupt or malicious or incompetent. It is an argument that structure matters more than intent. A system that allows non-enforcement of mandatory law without consequence, under vague standards, will eventually operate on power, not law, regardless of who occupies the bench. What this means for ordinary people. For ordinary litigants, this reality has consequences. It means rights exist, but enforcement is uncertain. Procedure can be weaponized. Seeking justice carries asymmetric risk. Silence is often the rational choice, and when people stop filing claims, the system reports success. But that success is built on deterrence, not justice. Closing. A legal system governed by law must be willing to say, mandatory rules are mandatory. Error has limits. Discretion has boundaries. When it doesn't, judicial error stops being a mistake and becomes authority. That is the quiet transformation happening in modern civil justice. And until it is named clearly, it will continue, not because it is lawful, but because it is allowed. Addition. Error is not punishment. Delay is the problem. Let me be clear about something. No one is asking to punish judges for legal error. No one is talking about sanctions, discipline, or personal liability. Judges are human. Mistakes happen. But in every system governed by law, mistakes are corrected immediately when mandatory rules are violated. If a traffic ticket is issued illegally, it's voided. If a contract violates statute, it's unenforceable. If an agency exceeds its authority, its action is set aside. Only in courts do we accept the idea that an illegal ruling can remain operative, sometimes for years, simply because it was issued by a judge. That delay is not neutral. An uncorrected violation of mandatory law becomes real power the moment it is allowed to stand. Judicial independence should protect judges from pressure, not protect illegal rulings from immediate correction. The end.